Welcome to the Divorce Lawyers podcast, where we delve into the complexities of family and divorce law in Ontario. I'm Deepa Taylor, and in today's episode, we're discussing a critical topic that affects countless families: child custody. Whether you're navigating a recent separation or just planning for the future, understanding the essentials of child custody is vital for every parent. Before we dive in, a quick reminder that this podcast is for general informational purposes only and does not constitute legal advice. For personalized guidance, please consult one of our lawyers by visiting DivorceLawyers.ca. Now, let's get started. Child custody is one of the most significant and emotional aspects of divorce or separation. In Ontario, child custody refers to the rights and responsibilities a parent has towards their child, including decision-making on important aspects like education, healthcare, and religious upbringing. Generally, custody arrangements can either be sole custody, where one parent has the authority to make all major decisions for the child, or joint custody, where both parents share decision-making responsibilities. It's important to note that custody is distinct from access, which pertains to the time a child spends with each parent. One key factor in determining custody is the best interests of the child standard. This is the legal benchmark used by courts to decide custody matters. When making decisions, the court considers various aspects such as the child's emotional and physical well-being, their relationship with each parent, and the stability each parent can provide. It's crucial to understand that the child's best interests always take precedence over the parent's preferences. Now let's explore the different types of custody arrangements. In a sole custody arrangement, one parent has full responsibility for making decisions about the child's upbringing. The other parent, known as the non-custodial parent, may have access or visitation rights, but doesn't have a say in major decisions. In contrast, joint custody involves both parents sharing decision-making responsibilities, which requires a high degree of cooperation and communication. It's important to note that joint custody doesn't necessarily mean the child spends equal time with both parents, but it does mean that both have equal input into major life decisions. Another type of arrangement, though less common, is split custody. This occurs when each parent has sole custody of one or more of their children. For example, one child may live with one parent while another child lives with the other parent. Shared custody, on the other hand, is when the child spends an approximately equal amount of time with both parents. This arrangement also requires a great deal of cooperation and is often seen as beneficial for the child, provided the parents can maintain a cooperative relationship. Choosing the right custody arrangement depends heavily on the specific circumstances of each family and what works best for the child's well-being. A parenting plan is a crucial component of any custody arrangement. It's a written agreement that outlines how the parents will raise their child after separation or divorce. This plan should cover key areas such as where the child will live, their education, healthcare, and religious upbringing. When developing a parenting plan, it's essential to focus on the child's needs. Ensure that the plan prioritizes their emotional, physical, and educational well-being. The plan should be detailed and specific, covering the child's daily routine, holiday schedules, and decision-making processes. Including a dispute resolution mechanism is also wise, as it provides a process for resolving disagreements, such as mediation or arbitration, without returning to court. A well-structured parenting plan not only helps in the day-to-day management of your child's life, but also minimizes conflict between parents. When parents can't agree on custody, the court may need to intervene. In Ontario, the court's primary concern is the child's best interests, and they have several tools to assess what that looks like in each case. One such tool is the involvement of the Office of the Children's Lawyer. The OCL may be brought in to represent the child's interests in court. They might assign a lawyer or a clinician to conduct an investigation, which includes interviewing the child, the parents, and other relevant parties like teachers or counselors. The OCL then provides a report to the court with recommendations on custody and access arrangements. It's important to understand that while the OCL's involvement can be incredibly helpful in complex cases, it can also add time and emotional strain to the process. Parents should be prepared for this possibility and remain focused on the best outcome for their child. High conflict custody cases are unfortunately common and can be particularly challenging. These cases often involve serious issues such as allegations of abuse, neglect, or one parent attempting to alienate the child from the other. In such situations, the court may take additional steps, like appointing a parenting coordinator or ordering a psychological evaluation of the parents and child. The goal here is to protect the child from the harmful effects of parental conflict and ensure their safety and well-being. If you find yourself in a high conflict situation, it's crucial to document all interactions meticulously, seek professional legal advice, and consider the services of a mediator or counselor to manage the situation. Co-parenting can be challenging, especially after a contentious separation, but it's essential for the well-being of your child. To help navigate this new dynamic, it's important to keep communication open. Use a neutral tone and focus on the child's needs. Tools like shared calendars or co-parenting apps can help manage schedules and communication. Consistency is key as well. Establishing consistent rules and routines across both households provides stability for your child. It's also crucial to avoid negative talk about the other parent in front of your child, as this can be confusing and damaging for them. Be flexible because life is unpredictable, and plans may need to change. Flexibility can reduce tension. And don't hesitate to seek professional help, whether through legal counsel, mediation, or counseling, to resolve conflicts or manage stress. Before we wrap up, let's address some common misconceptions about child custody. First, there's the myth that mothers always get custody. The reality is that custody decisions are based on the best interests of the child, not the gender of the parent. Another common myth is that the child can choose where they want to live. While a child's preference may be considered, especially as they get older, it's just one factor in the court's decision. Then there's the misconception that if we have joint custody, we'll spend equal time with the child. In reality, joint custody refers to decision-making, not necessarily the division of time. The time-sharing schedule is a separate matter. Finally, there's the belief that custody arrangements are set in stone. In fact, custody arrangements can be modified if there are significant changes in circumstances that affect the child's well-being. Child custody is a complex and emotionally charged issue, but understanding the basics and knowing what to expect can help you navigate the process more confidently. Remember, the goal is always to act in the best interests of your child and to ensure they feel loved and supported by both parents. And thank you for joining me today on the Divorce Lawyers podcast. I hope you found this episode informative and helpful. If you have any questions or need legal advice, please reach out to a qualified family lawyer. Until next time, take care and remember to put your child's needs first.